because we are married doesn't mean that our spouse has implied powers under the power of attorney. In fact, if you have an account that's in your individual name, such as an IRA, and your spouse calls to obtain information about a balance or the required minimum distribution, which is required annually, they will not speak to your spouse simply because they are your spouse. So when we have joint assets that are owned jointly, that's not as big of a problem. But anytime we own something individually, even for a spouse, power of attorney is incredibly important.
I have been told that if somebody has power of attorney, my power of attorney can act on my behalf, they can only do that if I'm incapacitated. Is that true, or can they act on my behalf anytime because they have power of attorney, because I've given them power of attorney?
So that's a great question, and it's a really big misconception that people have, that the power of attorney is only effective upon incapacity. And in fact, under the Florida statute, that is untrue. The document is effective immediately upon being signed. What it is important for me to convey to my clients who may be concerned about the broad scope of powers that are being granted under a power of attorney is that the law protects the principal or the document maker in saying that the agent can act on the principal's behalf and at the principal's direction. So it is not carte blanche powers to that agent to do whatever it is that they want to do. I often tell my senior clients that seniors have the right to make bad choices. And just because we're making what our loved ones would consider a bad choice doesn't mean we lose our autonomy. And so it is a slippery slope, and it is difficult sometimes to see where those lines are to be cut. But we do our best to not only educate our clients, but the agents as well, and let them know that their actions are monitored and they are regulated by statutes, and they need to act proper in accordance with the document.